placing some peaceful negotiation as the first and most noble resort. This quote serves as a powerful preamble, setting a profound and visionary tone for this 5-day training program. It acts as a guiding principle, framing the spirit of mediation and conciliation that will define our time together. A very good morning to everyone present here. It is my privilege and honor to extend a warm welcome to all the distinguished guests, respected faculty members, dear participants and students present here today at Damodaram Sanjeevaya National Law University, Visakhapatnam. We have gathered here on this significant occasion to mark the inaugural ceremony of the 40 hours mediation training program, a step that reflects our collective commitment towards strengthening alternative dispute resolution mechanism and fostering a culture of dialogue, understanding and peaceful resolution. We are deeply honored to have our Honorable Vice Chancellor, Professor Dr. D. Surya Prakash Rao. I would like to express my sincere gratitude to Honorable Justice Vikram Nath, whose approval and encouragement lend immense credibility and inspiration to this program. His contributions to the field of justice continue to guide aspiring legal professionals across the country. It is a matter of great pride for us to welcome our chief guest, Honorable Justice Subba Reddy Sappi, Judge of High Court of Andhra Pradesh. We are equally privileged to have with us our guest of honor, Ms. R. Ratnatara ma'am and Ms. Sudarshana Sundar ma'am, Senior Trainers of Mediation and Conciliation Project Committee. This training program is not just about learning techniques. It is about cultivating patience, empathy, and ability to resolve conflicts with sensitivity and fairness. And thank you for being a part of this meaningful initiative. Thank you.
Justice Vikram, who is the chairman of Mediation and Conciliation Project Committee and which approved this program to Damodaram Sanjeevaya National University. And actually, as far as national law universities are concerned, the first program was conducted in Rajiv Gandhi National Law University, Patiala. This is the second one for the national law universities. So it is a pride moment for DSNLU to have 40 hours mediation training program, for which I am very happy. I am honored that Honorable Justice Subba Reddy Sappi, Judge, High Court of Andhra Pradesh, has kindly consented to be the chief guest and he accepted to give the inaugural address. Thank you very much, sir. In spite of his travel this day, in order to come to Visakhapatnam, actually yesterday he cancelled his travel plan from Hyderabad to Vijayawada and he stayed overnight in Hyderabad airport and he came morning to DSNLU. Thank you very much, sir, for your commitment and honor to the academic program. I also welcome Mr. R. Ratnatara and Mr. Sudarshana Sundar, who were the senior trainers of Mediation and Conciliation Project Committee, who specially came from Chennai to conduct this program for 5 days continuously to complete this 40 hours program. It is a process through which the disputes are being settled at village level, at ward level, panchayat. 5 members of the particular body has to settle the disputes whenever these disputes were there among the villagers. As we know, the Rigvedic period has a well-developed institutions like Samiti and Sabha, where Republican form of governments were there. So Republican form of government itself is the elected sovereign authority. Sovereign authority is an elected sovereign. So it was known to ancient Indians, 16 Mahajanapadas until Magadhan ascendancy. And the corresponding Greek city-states, each city itself is an independent republic state in Greek, where Socrates and Thales and all these people were there who had been nurtured in the democratic process. So here that's why the mediation is a method which has been recognized in the human history since ages past. And as because of the common law system, because of this regular litigation system which was introduced by the Britishers, and prior to that also we had our own systems. And Southern Nizam Adalat and these 1773 Regulating Act, their Supreme Courts were appointed. And the common law system, the Anglo-Saxon jurisprudence, the cardinal principle is locus standi. When the person comes to the court, court has to see two things. One is whether that person has a right to stand before the court, or whether the court has the jurisdiction to try the case. This was the traditional practice of the common law courts, but because of the judicial activism from post-Manhattan scenario, this locus standi principle was liberated and public interest litigation was developed. The Indian Supreme Court, after having adopted different ideologies, previously at one stage, when a person has one ideology, he was identified as a positivist. If another person has ideology, a sociologist, a naturalist, a historical jurist. But now the present trend is, the ideologies are different. Whenever the judge has to decide a case, he has to apply the appropriate ideology to the appropriate case. That's why at one stage, law is dictate of reason, dictate of God, dictate of nature. And sovereign command sanction is the positivistic approach. And historical jurists have to develop this particular national spirit psychology. Law and language are indigenous. They are not foreign to become. So now also in India, the new trend was started. The criminal laws were nationalized. So the national components were taken into consideration when we are bringing and reforming and recodifying those criminal laws. So here that's why the law is national spirit. So unless we understand the national spirit is the Puranas, the Indian legacy, the Hindu philosophy, or for that matter any secular way of life has to be promoted to understand and settle the disputes. And as we know, sociological school, which is promoting the logical experience. Law is an experimental value. Then why I am referring these things, today we are conducting this mediation. So different methods are there to solve the disputes. And particularly the neo-sociological jurists, particularly American realism, Oliver Wendell Holmes simply says law is not logic, it is human experience. So in order to settle the disputes through mediation, human experience plays an important role. And Thermo Frank and this pragmatism and rule skeptics and fact skeptics, all these approaches are jury matrix. So instead of studying the law, you should study the judge so that you can understand the pragmatic approach of that particular judge in solving the disputes. Now, we are fortunate, the Indian Supreme Court is developing this type of alternative dispute mechanisms, particularly arbitration and mediation acts were at one time combinedly were there, mediation act was separated. Now the judicial process gave more importance to these alternative dispute resolutions. So they are giving more importance to mediation. That's why the object of this particular project is also to train more and more people to get these techniques of mediation so that they can be recognized as mediators. When the disputes were arose, instead of going to the court, they can settle the disputes outside the court. That's why what are the characteristics of a mediator? What are the qualifications? The equilibrium. So mediator should be competent enough to know the culture, to know the society. So mediator is almost expected that he should be equipped with all the latest judicial process or legal process of the country. So I am very happy today DSNLU is proudly having this particular prestigious project sanctioned by Justice Vikramanand, who is the presently chairperson of this particular Mediation and Conciliation Project Committee of Supreme Court of India. So I welcome all the dignitaries and the guests, and I strongly believe that this program will be successful in the coming 5 days. After having 40 hours program, I have strong belief that all the participants who are being trained can be equipped with all these latest techniques of mediation. Thank you very much for giving me this
Now, extend our warm regards for his approval for this event. As they
And my first training was at Amravati for the lawyers, 40 hours training lawyers, which was conducted in 2023. And after that, we've been traveling, Sudeshana and myself, we've been traveling a lot to train the lawyers as well as the government officials and also the judicial officers also. And to talk about this mediation, we've been talking mediation under section 89 of the Civil to reduce the pendency of the cases pending in the various high courts. This mediation is the best method when compared to the other alternatives, arbitration, conciliation, because the reason is in mediation, the self-autonomy or the self-determination of the parties are there. When the parties are given the choice to choose what they want, which is not existing in any of the other area. That is one of the special criteria, or that is one of the unique concept of the mediation also. And apart from reducing the pendency of the cases, it is not only to reduce the pendency of the cases. According to me, mediation skills and the techniques is the soft skills which everyone needs to learn about it. And when this mediation training is taken to the grassroots level and also to the school level and for the college students also, there will be a cultural transformation in the society also. Because when we are talking about, even if it is a small passage dispute between two neighbors, the immediate thing is they don't sit across and talk with each other to resolve the problem. The first thing is they go to a lawyer, and the lawyer takes them to the court, and from the trial court, it goes up to the Supreme Court for a 3 feet, dispute between two neighbors. Now, if this mediation skills and techniques are being brought to every individual, if it is being taught, then there will be a cultural transformation in the society also, which ultimately will lead to peace and harmony. This is what I would want to share, apart from talking about the reduction of the pendency of the cases, the docket explosion. This mediation skills is needed for everyone. Thank you so much.
Thank you so much, ma'am, for your insightful words and motivation. We have Sudarshana Sundar ma'am, enrolled in the year 1988. She has handled critical and crucial matters of government agencies and banks. Trained by experts from USA, she is a senior trainer for the MCPC and a member of the Mediation Monitoring Subcommittee at Madras High Court. We now invite ma'am to deliver her speech of address to the gathering.
Always been a privilege coming back, and when Sir invited us, it was more of an excitement because we are also we are going to interact with students for the first time, because all these whiles we've been doing it only for professionals like lawyers and retired serving judges and retired judges and all those things. So to interact with university, because we always believe that if mediation has to take effect, it has to first reach to the students also, who are the next generation lawyers. So therefore, training them will be very essential. And as Tara pointed out, it is a life skill and it has to be affected at the grassroots level. Last year there was a convention, we had a mediation conference in Delhi. Our president spoke at length about how to take this, mediation to the grassroots level, because that is where it is way more essential, because we have very few courts catering to elite people. That's what she said, it doesn't reach the grassroots. So if it has to reach to the grassroots level, we must also make people understand their dispute and try to resolve them by themselves. I mean, empowering them to resolve their disputes would be the best way to make society peaceful, and there'll be a harmony in society. So for that, and Andhra Pradesh has taken that initiative of training the university students, and I thank Sir for taking this initiative to this level. Of course, our thanks to also MCPC for inviting us to give this 40-hour training, and it will be our pleasure also to do it. And there are a lot of things to talk, but because of paucity of time, I end my speech here. Thank you so much. Thank you all.
Thank you so much, ma'am. We extend a warm welcome to our Chief Guest, Honorable Justice Subba Reddy Sathi, Judge at High Court of Andhra Pradesh. He started his career in the year 1994 as an advocate, including as a standing counsel for various departments of the government. His journey from Aravali village to the High Court of Bench is a testament to the power of dedicated legal fraternity. We welcome you, sir, to august the gathering.
Professor Prakash Rao, Dr. D. Prakash Rao, Vice Chancellor, National University, distinguished senior trainers, Ms. Ratna Tara, and Ms. Sudarshan joined me when I was in Bhopal. As Mr. Vice Chancellor said, I had to change my plan and I just want to visit for the reason. Both the senior trainers, they visited Amravati and they trained our advocates for 40 years. And in fact, I have to say that now we are getting the results from that training. Some of the cases we report to the mediators, we are getting a good result out of mediation. So I thought it's my privilege to attend this meeting. This initiative approved by this MCPC, it marks a significant step, because now for the first time the committee felt that better let us even involve the lecturers and professors into this. For the reason, you are the person, you try to teach only the subject to the students. If you also teach this importance of mediation to the students, this is a step where, according to me, the students, because when you are teaching the different subjects to the students, they think that this is how the litigation is adversarial like that. But when you teach this importance of mediation, they think this is the impact or the output of this, so that that's what, in fact, after looking at that, the information sent it across to me. The initiation by Justice Vikramnath and selecting this national university and also involving the teachers, according to me, it's a step in weaving the threads of amicable settlement into a fabric of legal education that is only possible through the professionals, with the professors of the university. While mediation is often directed as to the practitioners, conducting this program specifically to the faculty of law, that's what I've been saying, it's idealistic. For the reason, you are imparting the basic education to them. Now we are making this as one of the subject whenever it comes to whenever an occasion comes. And the teachers, you are the multipliers of the knowledge. That's how you are trying to inculcate this importance of mediation to the students. You ensure that the next generation lawyers view the litigation not as the first resort but as a last resort, which lessen the harmony in the society. Mediation is no longer an alternative to the judicial process. It is in fact a complementary pillar that restores the constitutional promise to access to the justice. Is and forward-looking pillars of our justice system. It represents not merely an alternative to the litigation, but a complementary instrument that restores relationship, fosters communication, and upholds the constitutional promise to access to the justice. The roots of mediation in India, as Dr. Suryanarayan is speaking about, our panchayats. Professor, our Vice Chancellor spoke about just now about the civilization, ancient civilization, how the panchayats they were held and they used to resolve the disputes. This is embedded in our civilization ethics. Panchayats and village assemblies for centuries functioned as community-based dispute resolution mechanisms founded on dialogue, consensus, and respect. After Section 89 amendment to the CPC, probably professors will be knowing Afghan's Infrastructure Limited by the Apex Court, where the Apex Court clarified because that's the different high courts, different views are taken. Then the Apex Court clarified as to when the judges they have to refer the matters to mediation. That is one of the significant judgments of 2010. You people know about that. Then after Afghan, that arbitration conciliation is one type of legislation of the Mediation Act 2023. Of course, as you are aware, some of the provisions are to be notified by the central government, but yet now at least we can say a codified law is now in India. So for in the case of Mediation Act, it in fact Mediation Act now codified the procedures. Crucially provided the mediated settlement agreements with the same enforceability as arbitral acts. That's one area where it is notified. Probably within no time, probably have to expect probably these trainers there. That's what in fact I'm discussing the trainers in the VC chambers now. We'll expect very shortly the result. Apart from all these things, we are aware, Commercial Courts Act, Section 1 capital A, it mandates mediation. Without mediation, no suit will lie before the court. Section 5 capital A. That is patent automation. That's also where the Supreme Court settled the issue. And in fact, this commercial litigation is concerned now. They have been settling the issues. Apart from that patent automation, the other act is concerned. The Micro, Small, Medium Enterprise MSME Act 2006. Section 18 empowers that tribunals to resolve the disputes before approaching the parties to the court. Recent Supreme Court that Raksha Devi and Prakashan 2025 10 SEC with the litigation in the Supreme Court commenced in 2011. The notice was ordered in 2011. 2024, the Supreme Court ventured the mediation, and the advocate, it seems, going by the facts of that case, he visited the village. It seems it's a dispute among the always family members for partition like that. The advocate visited the village. He tried to mediate, and in fact, is successful, and that was settled in 2025. 2011 is the Supreme Court that we had to say another 10-15 years back. That maybe that is somewhere in 2000 or prior to 2000. Now in 2024, the issue was resolved by the mediators. In fact, the Supreme Court in that while it's a short judgment, the Supreme Court said the importance of mediation. It termed this Swadeshi mediation. Supreme Court says this Swadeshi mediation. Looking at the litigation which has been now resolved, the concept emphasizes that the lawyers must avoid in fact this observation Supreme Court award into mediation, into mediators who listen more than they speak, prioritizing harmony over victory. One more judgment, Nikita Gupta versus Yudanandan Gupta. The court also direct referrals of parties to mediation highlights that even in complex, there is a transfer petition where there is dispute between wife and husband. When yesterday when I've been to Bhopal also there is a Justice Kotesh is highlighting about this mediation, the importance of mediation, especially in this transfer petition between spouses from one state to other state. They are also resorting to mediation, and according to his lordship, he is also getting good result. This 5-day mediation training, you will explore the technical nuances that separate the successful mediator from a legal opponent. To understand the mediation is a completely different philosophy of justice. While the court looks back to find out who was wrong, when it comes to mediator, you always look forward to find how to make the things right. Because the courts, is always adversarial litigation. When it comes to mediators, they try to settle the issue amicably. They try to first give the confidence in the party, before the parties. They speak individually. They try to get what is the dispute, the court dispute. Then they don't even advise. They try to, in the advice in the sense, they don't give legal advice also. They try to settle the issue in that way that there will be one of the family member, he'll be acting as elder, the mediators. They take different roles in the caucus. That's how. And Madam Radha was saying, self-determination. In courtrooms, what we decide only fate based on the material before us. One party is always, one party is the winner, the other party will be the loser. But here in the mediation, always the self-determination principle ensures that the party remain the masters of their own conflict. No settlement is ever forced. End of the day, if the mediation is successful, both the parties are happy. Both the parties are happy because unlike the arbitration, this is we don't even pay that much because you say AFP. In house I'm only just speaking. Arbitration is something, this is a very costly affair now. But when it comes to mediation, very, very less. Very, very. Even parties did not do anything to the mediators. They try to that's what they act as like our brothers, sisters. They act as our mother and father. They take different roles at different stages. And in mediation, the important thing is confidentiality. No mediator shall disclose what happened when they are interacting with one party to another. They maintain utmost confidentiality in mediation. In fact, Mediation Act also codifies this safe space, allowing parties to explore compromises without fear, and their words will later be used, will not be used against them. That's very important so far mediation is concerned. And the positions are that the people say they want, but the interests are why they want it. A mediator is trying to look below the surface to find the compatibility interests, even when the position conflicts. That is the important role you are tomorrow, probably after this 40 hours training. You will be going, that is, but when you start looking into the background of the litigation, definitely you will be the successful mediator. And as I say, this caucus is a unique tool. The mediator will meet each party privately. The private sidebar allows for reality testing and exploration of hidden options that parties might be too hesitant to discuss in front of their opponents. Probably in this 40 hours, the senior mediator will be learning and they will be telling about how you have to use this caucus is concerned. Then, Mrs. Sundar is saying, natural reforming, reframing. Using techniques like paraphrasing and summarizing, a mediator strips away aggressive language and reframes insults into natural problems, neutral problems that can actually be solved. That's also one of the important passages probably you'll be learning. But whole problem, despite all this progress, the cultural hesitation and the lack of public awareness remain obstacles so far this mediation act is concerned. Institutions like this DSNLU, they are the laboratories where this Swadeshi path to peace will be refined. True justice does not always lie in a win-lose verdict. Often, it lies in a solution that satisfies the interest of all. It's only possible with the mediation. I urge you to embrace this workshop not as a mere certification, but as a shift in mindset, one that evolves, one that values empathy, neutrality, and emotional intelligence. I wish this 40 hours training program very success and look forward to the faculty of DSNLU in leading the charge in establishing robust mediation mechanisms across our state. I wish one and all will be a success, and thank you. Thank you.
Thank you, Your Lordship, for enlightening us that the alternative dispute resolution mechanism is the complementary pillar to uphold the constitutional promise for having access to justice. I may now request Dr. Vishwachandranath Madasu Sir, Registrar, Damodaram Sanjivya, National Law University, to kindly deliver the vote of thanks.
Good morning, all. On behalf of DSNLU, I thank Honorable Supreme Court of India and Judge Supreme Court of India, Vikram Nasser, for sanctioning this program for the intensive training for faculty and students of DSNLU for 40 years. I'm also thankful to Honorable Justice Subbareddy Sathi sir for accepting the invitation within a short time and coming here to deliver his valuable speech on mediation and interest of it. At the same time, I would like to thank Ratnatara ma'am and Sudarshan Sundar ma'am for coming here to train our faculty members and students, ma'am. I'm also thankful to Honorable Vice Chancellor sir for arranging this 40 hours program for the benefit of the students and faculty members. I would like to I request all the faculty members and the staff, students, utilize this program and be here for 5 years. Thank you very much for coming.